Hi, my name is Nicholas Height. I'm a lawyer licensed in Louisiana with over a decade of experience committed to working with adult and child survivors of intimate partner violence, stalking, and sexual assault. This video is only informational in nature, and even though I am a lawyer and I am going to be talking about legal topics, I'm not giving you legal advice, and nothing I say in this video should be considered legal advice. If you have questions about anything I talk about, or questions about your particular legal situation, you should seek out a licensed and experienced attorney who'll be able to provide you with legal advice specific to your needs. This video is designed to answer some frequently asked questions about restraining orders in Louisiana. While these questions are frequently asked, they are likely not every question you have, but hopefully they will help cover some basic points about court-issued restraining orders addressing domestic violence, stalking, and sexual assault. For purposes of a restraining order, domestic abuse includes, but is not limited to, physical or sexual abuse and any offense against the person, physical or non-physical, as defined in the Criminal Code of Louisiana. This doesn't include negligent or accidental injury and defamation. The harm must be committed by one family member, household member, or dating partner against another. Domestic abuse also includes abuse of certain adults when committed by an adult child or adult grandchild. A dating partner means any person who is involved or has been involved in a sexual or intimate relationship with the offender, characterized by the expectation of affectionate involvement without being paid for it, regardless of whether the two people currently or formerly live together. Stalking is the intentional and repeated following or harassing of another person that would cause a reasonable person to feel alarmed or to suffer emotional distress. Stalking shall include, but not be limited to, the intentional and repeated uninvited presence of the perpetrator at another person's home, workplace, school, or any place which would cause a reasonable person to be alarmed or to suffer emotional distress as a result of verbal, written, or behaviorally implied threats of death, bodily injury, sexual assault, kidnapping, or any other statutory criminal act to himself or any member of his family or any person with whom he is acquainted. Cyberstalking is the action of any person to accomplish any of the following: using electronic mail or electronic communication of any words or language threatening to inflict bodily harm to any person or to such person's child, sibling, spouse, or dependent, or physical injury to the property of any person or for the purpose of extorting money or other things of value from any person. Sending electronic mail or electronic communication to another repeatedly, whether or not conversation ensues, for the purpose of threatening, terrifying, or harassing any person. Sending electronic mail or electronic communication to another and to knowingly make any false statement concerning death, injury, illness, disfigurement, indecent conduct, or criminal conduct of the person electronically mailed, or of any member of the person's family or household, with the intent to threaten, terrify, or harass, knowingly permitting an electronic communication device under the person's control to be used for the taking of an action previously described. Cyberstalking is the action of any person to accomplish any of the following: using electronic mail or electronic communication of any words or language threatening to inflict bodily harm to any person or to such person's child, sibling, spouse, or dependent, or physical injury to the property of any person, or for the purpose of extorting money or other things of value from any person. Sending electronic mail or electronic communication to another repeatedly, whether or not conversation ensues, for the purpose of threatening, terrifying, or harassing any person. Sending electronic mail or electronic communication to another and to knowingly make any false statement concerning death, injury, illness, disfigurement, indecent conduct, or criminal conduct of the person electronically mailed to, or of any member of the person's family or household with the intent to threaten, terrify, or harass. knowingly permitting an electronic communication device under the person's control to be used for the taking of an action previously described. Sexual assault means any non-consensual sexual contact, including, but not limited to, any act provided in Louisiana Revised Statutes, Title 15, Article 542, or obscenity, Revised Statute, Title 14, Section 106. What is the legal definition of sexual assault? Sexual assault means any non-consensual sexual contact, including but not limited to any act provided in Louisiana Revised Statute Title 15, Article 541, or obscenity in Louisiana Revised Statute Title 14, Article 106. What kinds of protection orders are there, and how long do they last? Protection orders fall into two main categories: civil and criminal. A criminal protection order is typically issued as a bail restriction and lasts for as long as the criminal case proceeds, or at least as long as the person is out on bail. Alternatively, a civil protection order can be an order of protection from abuse or a civil injunction. An injunction can last forever and can include many of the same prohibitions against abuse and harassment, but is not automatically criminally enforceable with arrest. An order of protection from abuse is criminally enforceable, but generally only lasts for 18 months, though some portions of it can be made permanent. Generally speaking, restraining orders can prevent a person from contacting you personally or electronically, being physically near you, or generally interfering in your day-to-day life. In some cases, a restraining order can temporarily evict someone from shared housing, can require them to seek mental health care, and even pay for some of the costs that result from the harm they have caused. The specific type of relief you can get is going to depend on the type of harm that has been inflicted and the type of court action that you are pursuing. Ultimately, like all court orders or judgments, it is just a piece of paper that requires additional mechanisms like the police and the courts to have any enforcement action. For some cases, a court order is a highly effective deterrent and the risk of criminal penalty prevents further harm. For some cases, a court order merely adds fuel to a fire and can actually increase the risk of harm. You know your circumstances the best, and you should always try to do some kind of safety planning before seeking a court order. If you're working with a trained university or community advocate, that person can probably help you with this safety planning process, so you may want to reach out to them about that. No one is obligated to contact the police or participate in a police investigation regarding harm perpetrated against them. There is no obligation to file a police report in order for harm to be considered true and valid. There is no obligation to file a police report in order to be eligible for a civil order of protection. However, there can be value in having documentary evidence of harm if you plan to seek court intervention. That evidence can come in the form of a police report, along with many other things. No, there is no guarantee that anyone requesting relief in court will get what they request. In order to get a temporary restraining order that lasts for approximately 21 days following the filing of a petition, the court must see an immediate risk of harm based solely on what's written in the paperwork. To get a long-term order of protection, the evidence presented to a judge must demonstrate that it is more likely than not, or at least 51% likely, that the alleged harm did occur and that an order of protection is appropriate. If the alleged harm includes sexual abuse of a child, that burden of proof becomes significantly higher. Unlike criminal court, in civil court, no one is guaranteed an attorney free of charge. Everyone has the right to have an attorney of their choosing, and there are several organizations in New Orleans that may provide legal representation for no or little cost to qualified individuals. If you're working with a university or community advocate, that person may be able to help you connect with legal resources available to you. It is possible to have some provisions of a protection order made permanent. Those provisions regarding physical distancing and bans on communication can be made permanent. Most other terms of a protective order have an expiration date that does not extend beyond 18 months. However, it is possible to request that a protective order be extended beyond that 18-month limit following a secondary hearing on the issue. Alternatively, if the parties enter into a civil injunction by consent, the terms of that injunction can be indefinite. The law does not require payment of any court costs when filing a petition for protection from abuse. When a petition is dismissed, either voluntarily by the petitioner or involuntarily because of the petitioner's failure to appear or because the petitioner didn't meet their burden of proof, neither the petitioner nor the defendant can be cast with the court costs. However, if a petition is dismissed and ruled to be frivolous by the judge, then and only then can the petitioner be cast with court costs. If a petition is granted, then the defendant may be cast with the court costs and the attorney's fees, but that is up to the judge to decide as part of the court order. It is possible to request a protective order against a stranger if the stranger has stalked you and/or committed sexual assault against you. If a stranger has committed any other type of harm against you, you may seek criminal recourse, such as arrest and a subsequent bail restriction, or other types of civil recourse, such as a civil injunction or civil damages, but the law only provides an avenue to seek a protective order against a stranger with whom you have no prior relationship for stalking or sexual assault. In order to proceed with a court case, the defendant must be served with the pleadings and be given an opportunity to defend themselves. If you're not able to identify or locate the defendant, it is not possible to notify them of the proceedings and allow them to participate. As a result, if you do not know the name or location of the defendant, you probably will not be able to seek civil legal action against them. In the case of a petition requesting an order of protection, the defendant must be served personally, but a defendant doesn't have to be notified at their home. Notification can be delivered to a defendant at any location where you think they might be found, as long as it is delivered to them directly. Alternatively, it is possible to seek criminal action, which can cause an investigation to be undertaken and the defendant to be identified and located. Once a defendant is identified and located, then it may be able to pursue civil litigation against them as well. Yes, the process can be more complicated, but it is possible. As long as the defendant has sufficient notice of court proceedings and an opportunity to participate, it doesn't always matter where they are located. In order to give adequate notice to someone out of state, they must be personally served with the paperwork requesting a protective order. Additionally, they must be notified about the hearing, and proof of that notification must be filed with the court at least 30 days ahead of the hearing. Protective order cases typically move very quickly, and the hearing dates are less than 21 days apart unless the court grants special permission to set the hearing date outside of the legal limits. It depends on who the person is. Competent adults can file on behalf of themselves, their minor children, or an incompetent adult over whom they have legal authority. Competent adults cannot file on behalf of other competent adults or on behalf of anyone else over whom they do not have legal authority. The law requires that a defendant have the right to face their accuser, and it is important that people who have been harmed be given the chance to be empowered by acting on their own behalf. This is a common misconception. Unless you are identified as a defendant or there are specialized terms to your protective order, you cannot violate your own protective order. The terms of the protective order explicitly limit the actions of the defendant and no one else. That said, it is important to remember that a protective order is just a piece of paper and that avoiding potential conflict or harm may be a good idea, even after an order is granted. Additionally, having a protective order in your favor does not make you immune to subsequent claims based on your own actions against the defendant. You are not allowed to stalk a defendant just because you have a protective order against them. Yes, either party can file at any time to modify the protective order to change, dissolve, or extend all or some of the terms of the order. The LPOR has forms for this process. Not easily if you use the LPOR forms. Each petition has a single petitioner and a single defendant. Multiple petitions rising out of the same circumstances or event can subsequently be consolidated to be heard by the same judge, but the LPOR forms are designed such that a separate form must be used for each defendant. Many people do not want to participate in the criminal or civil court system to seek remediation from harm. Universities offer administrative processes to respond to harm that occurs within certain contexts, but not everyone wishes to participate in that process either. For some people, the courts are disempowering, and many believe that courts actively perpetuate the types of harm that are experienced in communities. There's no right or wrong way to respond to harm, and there is no right or wrong way to seek remediation from that harm. While court systems are built on the premise that change must be involuntarily ordered and enforced, some folks choose to pursue community-based alternatives built around voluntary systems of remediation. Almost all university staff are considered mandated reporters to some degree. In the case of child abuse, all staff are mandated reporters. Many universities also designate their staff as mandatory reporters for sexual assault, dating and domestic violence, and stalking, with the exception of confidential staff like medical and mental health professionals and clergy, requiring that these reports be shared with the university's Title IX coordinator. In the case of certain violent crimes, most staff are required under the Clery Act to report basic information to law enforcement, but do not have to share the names of involved parties. All staff are encouraged to report actions that may violate state or federal anti-discrimination statutes, and some universities may require that staff share these reports with their Title IX coordinator or the office that oversees their anti-discrimination policies. In any case, you should be aware that making a disclosure to a mandated reporter may result in the harm being reported to administrative or law enforcement offices. Regardless of what is reported, a person experiencing harm always has the right to opt out of any investigative or punitive processes. It is important to remember, particularly in the context of criminal reporting, that the opportunity to seek recourse may be time-limited or may become more difficult the more time that elapses between the harm occurring and subsequently seeking protections.